This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 30 years. Find out more at roundtablegroup.com.
Welcome to Engaging Experts. I'm your host, Noah Ballmer, and today I'm excited to welcome Mr. Garth Gartrell to the show. Now, Mr. Gartrell is the founder of StreeterWyatt Analytics, a firm specializing in executive compensation analysis, and he's the author of Emerging Compensation for Emerging Growth Companies. Additionally, he's an adjunct professor at Capital University and practices law on a pro bono basis. Mr. Gartrell holds a JD from Ohio State and an LLM from Harvard. He has over 10 years of expert witnessing experience. Mr. Gartrell, thank you so much for joining me here today on Engaging Experts.
Sure. Thank you.
Absolutely. Let's jump into it. You've made a long career as both an attorney and in academia. How did you first become involved in expert witnessing?
You have to ask the people that called me. It's never something that I've decided on as a business career. I guess the first case, I was a partner in another law firm, but got a call from a partner who represented Qualcomm and wanted me to get involved as an expert on some stock options and compensated related things. And then later, I got a call from a lawyer at actually one of the New York firm, huge New York firms that went a little bit bust. But prior to that, they had a case where they represented one of the big venture capital firm, Sequoia, and they had a former CEO that they had a dispute with, and so I was brought in to deal with the compensatory issues around his termination. And I guess from there, by word of mouth, over the course of time, I've had a continuing stream of lawyers contact me.
So you weren't looking to be an expert witness, it just kind of fell in your lap a little bit.
Yeah, that's right.
Had you used in your practice expert witnesses?
No, because I was not a litigator.
Ah,
I used them in the sense that, in representing public company boards, that we would also work with consultants to come up with compensation plans, and oftentimes they'd look to me for a referral to those kinds of people, or the valuation professionals in my line of work, valuation of stock options and compensatory awards is a pretty important milestone, and they often look to me for good referrals.
sure, absolutely. I remember when I was in law school, we didn't talk a whole lot about expert witnesses, how they're utilized, how they're found, things like that. So it's interesting. It can be kind of a new thing. So even as an attorney, when you were first made an expert witness, what was that process like to you?
Well, the big thing I learned, because like most people, I didn't jump into it on a planned basis. I didn't really have any background. I'd say the thing that I learned pretty early on is you have to kind of divorce yourself from the enthusiasm of the lawyers and not let them push you beyond what you feel you can represent. And I think perhaps in those early days, always I represented things that I felt I could say to a judge or a jury based on my experience. But you have to learn to resist those lawyers, and they're fairly few. Most lawyers want you to just be credible,
Sure.
want you to stay with things that you can defend, but there are occasionally lawyers that want to extend you beyond your comfort zone, and I would say you have to work hard to avoid that. So that's the that's the clearest lesson I got. And I think that most lawyers that I've encountered are truly honorable in the sense they just want you to be credible.
Yeah, I've heard from a lot of my guests that by and large, their experiences are very positive. They just want the neutral truth, which of course is the job of an expert witness. However, in those edge cases, that is something that new expert witnesses need to be prepared for. So I want to dig into that just a little bit more with, again, in mind, this isn't something that comes up a lot, but it does come up. So once it happens, what are the sorts of things that those attorneys will do to kind of push you a little bit beyond what you're comfortable with? And how specifically do you avoid it or deal with that kind of pressure?
Yeah, so early on, now the first two cases that I mentioned to you, those were great lawyers. But quickly after that, I found that a few lawyers had a preference for destruction of the other side.
Hmm.
Um, and use of inflammatory language. And you just have to dial that back. You have to imagine that your words are being read afterwards and that you want to be proud of what you've said. And it's kind of a golden rule type. You want your words to read like a golden rule, treat others as you would have them treat you. And so those are the kind of instances that if you follow that advice, I think can get you in big trouble, can get you kind of a black mark, especially for a judge. They want to know that you're relying on the science. Now, that doesn't mean you can't be strident in your criticism.
Right. Do you find that that happens more or less or about the same depending on you whether you are on the plaintiff or the defendant side?
Yeah, I think I'd have to say that you get a little more of that pressure from the plaintiff standpoint.
Hmm.
Uh, but as I say that, I can think of defense counsel cases where that seemed to be true a little bit. But like I say, mo most lawyers do want you to keep it at a non-personal level. They do very much want you to call out the weaknesses of the other side.
When you say call out the weaknesses, to what extent does the expert witness play a role in trial strategy? Are you just getting up there and talking about your expertise and letting the chips land where they will? Or in conversations with the trial team, do you try and poke holes and have some idea of some strategy that might aid your attorney?
Well, a couple things. First of all, I think you have to pick your battles. And this is another thing that I've learned. A trial is no different from a lot of other communication. You have to boil it down to no more than four or five things of essence. I had a case, and this was fairly early on, where the amount of mistakes and indicators of bad process on the other side were so many, and I think I went overboard in terms of just overloading the judge, and that taught me that I had to limit it, not just for the judge, but one of the toughest parts in this whole process is educating your own counsel. There's only so much they can keep up with.
In terms of educating your counsel, how do you go about doing that? How important is it that the counsel becomes not an expert but versed somewhat in your field to put on a proper, performance in court?
Yeah, again, I think it kind of boils down to the same thing of identifying the big picture items, because you got to remember that, especially in my area, sometimes executive compensation is the predominant issue. Typically, it's a bit of a side issue. It
Hmm.
often fits within the valuation. So you got to remember that these guys have it's incredibly hard to be a litigator. and they really can't get their head around the minutia, especially of a side issue. So you've only got a limited number of opportunities, and you've got to pick your moments and make those the kinds of things that help. My experience as a lawyer, I think, has helped a great deal. They're not my wins or losses, but if I
Sure.
look at the wins or losses of the the person's paying my bill, one of the most successful cases from that perspective was uh, I identified that the witness on the other side was really trying to buffalo the court, and that happens very routinely. Um, but in this case, and this was one of the most high profile guys in the country. Um, but I knew from my legal training that what he was trying to do in terms of a corporate issue was uh, illegal, at least in California. Now, this happened to be a Delaware law case, but I could say with a clear head that what he was proposing was illegal in a lot of states, including the biggest state in the union. I think that had a dramatic effect on the outcome of the case.
Do you present information differently when you are at a bench trial, when it's the judge, as opposed to a jury trial? Do you change the way that you interact, your demeanor, anything like that?
I can't really say that I do, except that I think in the bench trials, the court is more involved in the back and forth and may question you directly. Um, and it certainly is important that you be concise and really listen carefully to what the judge is asking.
Sure.
And so in that sense, I would say, you always want to be attuned to the question, but when it's your lawyer asking the question, he or she can take care of any aspect of unclarity, whereas with the judge, you really only get one shot and you better get it right.
Do you ever use visual aids with either the judge or with juries? Does that help you express some of these more complex concepts?
On occasion, yes.
Do you build them yourself?
I often do, yes.
Do you find that visual aids are useful also in report writing?
Oh, absolutely. I think they're essential. I don't know that I've completely mastered it, but it's something that I continue to try to work on to make it as scientifically accurate, but as understandable as possible.
Sure, absolutely. Let's talk about preparation a little bit. How do you get ready for a deposition? How do you get ready for trial? What techniques do you like to use to get yourself both prepared in terms of the materials, but also in the right headspace to be ready to go when you're peppered with questions?
Well, don't worry about it too much. I think the things that I talk about, I've worked on for so long and written about so much that I'm going to be much better versed than the questioning lawyer ever does. Now, have it ever is. Now, having said that, the way I approach a case is I try to imagine a Venn diagram where I try to imagine my scope of what I can testify to and what I can feel absolutely strong about. And I try to identify the ultimate client's perspective and what they're looking to accomplish. To the extent there's a lot of overlap between the two, then I feel comfortable. I put a lot of work into my opinion. So I make sure that everything that I want to say is in my opinion. And then it's really just a pretty easy matter of reading my opinion. I will read the depositions of the parties over once again. Then I'm typically pretty relaxed when I go either into trial. It always reminds me of something Mark Twain said. He said, "If you tell the truth, you never have to remember anything." And the truth is what you believe it to be in your experience. So as long as my report is consistent with something that I believe to be factually correct, it doesn't take a whole lot of preparation. So I'm typically comfortable billing at a fixed fee, um, especially for that part, because I really don't believe it's going to take a whole lot of time in the typical case. There are exceptions.
Speaking of billing, do you have any special terms that you like to put into contracts to protect yourself? Do you like to take retainers? What's your billing structure like?
Well, I do like to take retainers. I will always take a retainer if it's an individual. I don't care how rich somebody is, they don't like to write checks. And I stay ahead of that. And as an expert, I mean, every expert knows that your leverage goes away once you've given up a report or once you've testified. So yes, I always take a retainer. I'm always concerned that in a litigation matter where you've already got two sides that might be at each other's throats, that I don't want their litigation matter to become my litigation matter. So most of my engagement letters have not just a hold harmless, but they have a duty to defend. If I'm comfortable enough in a situation, and in those rare instances where I get pushback, I'll agree to a hold harmless only. But I most certainly do. It's never happened. I've never had an instance where somebody's, tried to come at me because of an opinion. But, it only takes one time. So I work hard to make sure the engagement letter reflects those kinds of provisions.
As somebody who's been doing this for quite a while now and been watching it for even longer as an attorney, have things changed in a noticeable way vis-a-vis expert witnessing? In other words, has something like technology changed? Has the willingness to use expert witnesses or the time at which they are brought into a case changed? What have you seen over the years, and where do you see it going in the future?
Well, I can only speak specifically to my area, and
Sure.
it has grown quite a bit. 40 years ago, I don't think they would even know what an exec comp expert was. They might get in as an expert some person who was in divorce cases. They often have a person who can make some judgment as to what the spouse could earn. So it's kind of a job function expert. And those types of people, I mean, they're kind of completely different. They don't spend actually that much time on compensation. They spend a lot of time on somebody's basic skills and education level. And so now and the types of people who might have done that also would have been the general valuation consultants who don't really do compensation. They do general business valuations, but they have kind of a tangential understanding of compensation, and so they have ventured into the area of compensation. That has changed a lot. Fewer and fewer valuation consultants wander into that, at least on high value cases, because they get in a lot of trouble. It's kind of easy to run circles around a valuation consultant. They will often leave out components of compensation. So less and less you see that. But for a case where the individual can't afford a lot of fees and it's not a big dollar value, case, you might see that. But so there's no question that there's been a seismic shift in the number of cases in which a lawyer has decided they need an exec comp expert.
Sure, absolutely. Have you done a significant amount of work over Zoom or other virtual means?
Yeah, it's since the pandemic, that's been the predominant method. I've almost all of my depositions are remote, and that's great because I spend my time in the Eastern and the Pacific time zone. Trials are still, I think, mostly as they're coming out of the pandemic, remote. I just had a New Jersey case settled. I would have had to show up there. I have a case coming up in the Northern District of California. I'm led to believe I have to show up there. But for the most part, I've testified remotely over all of the last 4 years.
Is there a difference? Is the demeanor difference? Is it harder to connect with a jury, for instance, or is it largely the same?
Well, I think it's a mistake to try to connect with the jury.
Oh, how so?
Well, that's a lawyer thing. An expert, I don't look at the jury. I look at the person questioning. So no, to me, there's no difference. I'm talking to the person asking the questions, and whether it's a judge or jury, I understand other parties are listening. But again, I just don't feel any tension. Early on, I used to get pretty nervous, but now it's just like you and I are having a conversation.
Sure, absolutely. When you're working on a larger trial team where there might be multiple experts, paralegals, maybe even consultants, how much interfacing or interaction do you have with the other members? Do you work with other experts on the team, or is it largely compartmentalized?
It's largely compartmentalized, but not entirely. There are certain things that I need to know about what they need to know so that I can do my job. And sometimes it's helpful to see how my own compensation valuation usually fits within the business valuation. So there's some linkage. Now, that being said, I think it is helpful, and I believe the lawyers want you to largely stand independently of the other consultant. So there's not a whole lot of coordination typically. Again, I need to understand what it is they're trying to accomplish
Sure.
so that I can give them the perspective that they're looking for. But I think the counsel wants you to say, by and large, that you're independent and unaffected by the opinions rendered by other experts. Um, when there are, in those instances where there are 7 or 8 other consultants on various other issues, I'll have virtually no communication with most and very limited conversation with some.
That's really interesting. Do you have any cases that really stood out to you as either meaningful, in as much as they changed the way that you go about expert witnessing or reinforced something that you do as an expert witness? Are there any pivotal cases in your career as an expert that you can talk about?
Yeah, there was one case in particular that I knew the expert was selling a lie to the judge, and was masquerading as a deep and dark math expert. And I've got a pretty fair math background myself. I knew he was stretching concepts way beyond what they could do. But I felt a little self-conscious about my lack of recent math credentials. And that case is the one that caused me to, I did what I thought was really good work, but I thought, look, if I'm going to continue to get calls about this stuff, I want to have credentials that are more in sync with my CPA credentials and less what people think of as a lawyer. So that's why I went and in my mid-60s started a graduate degree in the School of Industrial Engineering at Georgia Tech on data analytics. And so now there's no question about my ability to understand and articulate those issues.
Sure, absolutely. Before we wrap up, do you have any marketing tips, or is there a specific way that you like to get yourself out there? Do you find expert witness referral agencies useful?
Well, yes, they are useful. In answer to your second question, and the answer to your first question, I do know marketing. I'm not at that stage in my life where I don't even think I maintain my website anymore. I still do writing, and I suppose that comes across when people do some kind of search. Most of my cases are word of mouth, but I have gotten some pretty decent cases through a couple of, I guess I would call them headhunting agencies for experts. But most have come from, I don't even know how the word gets around, but
Sure.
At 70 years old, that works for me and has worked out pretty well.
Absolutely. What is, at the end of the day, what's meaningful, what's important about expert witnessing? Why is it important that there are expert witnesses?
I think they help sharpen the issue. For me, they help me stay engaged. In my teaching, it gives me real life relevant data points to deliver not just to the undergraduate students, but especially to the graduate students in the MBA program. So for me, it's the completion of a circle in a career I never thought I'd have at this stage of my life, that between the teaching and the expert witness, and I
Right.
still do a lot of board consulting, and I can tell members of public company boards the kinds of things that I see in a litigation context, and they're of course very interested in that. The last thing they want to do is be hauled into court for some kind of board breach of fiduciary duty issue to their shareholders. So
Sure.
it's a circle that's full and engaging, and I assume that helps all experts. But I am hopeful at the end of the day that more experts that I encounter on the other side will be less concerned with winning and more concerned with giving testimony that's truthful and professionally sound.
Sage advice. Mr. Gartrell, thank you so much for joining me here today on Engaging Experts.
Yeah, thank you.
And thank you to our listeners for joining me for another episode of Engaging Experts. Cheers.
Thank you for listening to our podcast, Engaging Experts. Our show notes are available on our website, roundtablegroup.com.